Hello and welcome back to another video on my channel. Today we're going to be taking a look at the Supreme Court decision that we can expect in the next year or so, which will be re-examining whether or not birthright citizenship is going to continue to be the status quo. So again, this comes off the heels of Donald Trump's executive order almost a year ago that sought to limit birthright citizenship to the births of children to at least one U.S. citizen. Now that is contrary to the current understanding which has existed since the 1898 decision in Wong Kim, which found that being born on the soil alone without a few limited exceptions was enough to grant birthright citizenship. So let's go ahead. Again, the court has agreed to take this up, so we can expect to see that in the near future. And again, so the Wong Kim decision, they looked at the 14th Amendment clause stating all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So since then, the clause has been understood to grant citizenship to anyone born in the U.S. regardless of their parents' immigration status. From there, we can see that since then, the Ninth Circuit and a New Jersey federal judge have both found against the Trump admin. And so in response to that, the president has said that those courts got it wrong, particularly in their understanding of the meaning of the phrase subject to the jurisdiction thereof. This second clause, if it merely means subject to answer to the laws, or can be held accountable by the United States for violating the laws, if it's merely meant as a regulatory jurisdiction, then it would be redundant and add nothing to the first phrase, arguing that we should give it meaning before we assume that its meaning was redundancy. Trump has conceded, though, that in the first half of the 20th century, the understanding of birthright citizenship as it currently stands has been the case for a long time. But that history of treating it as such shouldn't have any influence over the clause's original meaning and the public's original understanding of it in 1868. And again, that argument is going to hit home for this current Supreme Court, which is very textualist and originalist. So that will be a very strong argument before the court. Now, the opposing side is arguing that that decision would neither be originalist nor textualist, and the Trump admin is merely seeking out a post hoc rationalization for a predetermined policy outcome. Now, I think that's a bit refuted by the dissent from the actual opinion. We're going to get to it later. But the groundwork for the Trump administration's argument has been laid since 1898 in that dissent. And of course, they are capitalizing on that groundwork that was laid. So both are kind of right in that sense, but it is more than a mere post hoc rationalization. So let's go ahead and take a look at the statutes. Civil Rights Act of 1866 happens. It doesn't get followed as well as it should, and so it's followed by the 14th Amendment 2 years later. So the language in 1866 is, be it enacted that all persons born in the United States and not subject to any foreign power, yada, yada, yada. Now, the renewed version in the 14th Amendment is slightly different, and this is where all of the major arguments in the Kim case are going to come from, and I believe that's also where we're going to see the Trump admin's basis for its argument that this is the incorrect understanding of subject to the jurisdiction thereof. So let's look at the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So that discrepancy is really what these arguments are going to hinge on. Before we get into the case, I want to briefly just tell you what 4 arguments to look out for when the Trump admin takes this before the Supreme Court. So again, we're going to, of course, see what's already been mentioned, that being the original meaning of subject to the jurisdiction thereof. This would be the core claim. Here, the Trump admin would be arguing that the court in Wong Kim misread citizenship clause by treating subject to the jurisdiction of thereof as redundant and losing the meaning it was supposed to have. So keep an eye out for that. The second one is going to be that the majority in that case was selective in their transplanting of English common law. And so there, we're going to see it as we go through the case, that the court was relying on English common law, such as the soli. I don't know how to pronounce that, but that basically means just the soil or born there, birthright citizenship. And this is common law idea without accounting. And there the issue would be that they didn't account for the American constitutional differences. And there you had to be loyal to the king, and that was automatic. Whereas our system and what the U.S. broke away from that for a system that was consensual government. And so that would sort of undermine the transplantation of that common law doctrine in this case. The other thing we're going to see, of course, is the argument that the amendment was aimed at former slaves and was never intended for universal birthright citizenship. Again, 1866 Civil Rights Act was aimed at assisting former slaves gain rights, and when it wasn't really respected or upheld, that's when we saw the 14th Amendment in 1868 step in to make things very clear and get rid of the difference of opinions amongst the states. So that, of course, will be an argument that the Trump admin relies on. The next one will be that children of illegal or temporary aliens were never contemplated in this case that was decided. And so this case should be limited because the parents had proper domicile, and then this should be cabined to that instance. But where the parents do not have a legal domicile in the United States because they are illegal residents, well, then that is excluded in that case. So those are the four arguments. So let's take a look at the case. And before we get into it, I want to just clarify, we are, again, looking at this whole topic through an academic and intellectual lens. And so I hope the comments can reflect that, but you're going to do what you're going to do. Let's get into the facts of the Wong Kim decision. So again, Wong Kim was born in 1873 in the city of San Francisco. He was a laborer. His father and mother were persons of Chinese descent, and they were subjects of the Emperor of China. They were, at the time of his birth, domiciled residents of the United States, having previously established and still enjoying a permanent domicile and residence therein at San Francisco. In 1890, Wong Kim departs for China on a temporary visit. He then returns by sea in the same year and was permitted to re-enter the country on the grounds that he was a native-born citizen of the United States. In 1894, he goes on another temporary visit, thinking, I'm a native-born citizen. When he comes back, this time he gets a different reception, and he is turned away and told he can't come in, denied such permission on the sole ground that he was not a citizen of the United States. So obviously we can see how this is going to lend itself to the question of birthright citizenship, and that's how we get the court interpreting the 14th Amendment here. So here, the majority is going to ultimately find that this is that clause and subject to the jurisdiction thereof is somewhat of a redundancy, and that's where the dissent is going to disagree. So let's get into that. All right, so here the court is going to get into that idea we touched on earlier, jus soli, and we're going to see what they have to say about that. At the time of the adoption of the Constitution in the United States in 1789 and long before, it would seem to have been the rule in Europe generally, as it certainly was in France, that, as said by Pothier, citizens, true and native-born citizens, are those who are born within the extent of the dominion of France, and the mere birth within the realm gives the rights of a native-born citizen independently of the origin of the father or mother and of their domicile. And again, the arguments we could see posed against this is that our system was different than the governments of Europe, which were primarily monarchical, and your loyalty was automatic. Here in America, we established a more of a consent of the governed approach. So keep an eye out for that argument in the near future. The rule of country of birth, jus soli. There we have it. All right, and so here the Supreme Court is going to take a look at Chief Justice Marshall's previous interpretations of the similar phrase in a well-known case of the exchange, and here the words, in the United States and subject to the jurisdiction of, in the first sentence of the 14th Amendment of the Constitution, must be presumed to have been understood and intended by the Congress which proposed the amendment and by the legislatures which adopted it, in the same sense in which the words have been used by Chief Justice Marshall in the well-known case of the exchange. And that would be this territorial meaning of the phrase as the equivalent of the words within the limits and under the jurisdiction of the United States. And so that's where you get that more general territorial idea and not that idea of loyalty or allegiance that the dissent is arguing for, and we're going to move on to that. Okay, so here is where the dissent is getting its idea that, or its argument for the proposition that subject to the jurisdiction thereof has more meaning than just has to follow the laws. Here they're going to pull that from the Elk versus Wilkins decision. I won't read the full thing, but you can pause and do so. But essentially they have this line here, and owing no allegiance to any alien power should be citizens of the United States. The persons declared to be citizens are all persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject to their political jurisdiction and owing them direct and immediate allegiance. So again, pulling this from a prior case, analyzing the same, stating this is where we should derive the meaning from, not Chief Justice Marshall's the exchange, and this would give significance to the clause instead of finding it to be somewhat redundant. So here then goes on to say, now I take that the children of aliens whose parents have not only not renounced their allegiance to their native country, but are forbidden by its system of government as well as by its positive laws from doing so, and are not permitted to acquire another citizenship by the laws of the country into which they come, must necessarily remain themselves subject to the same sovereignty as their parents. So essentially saying that if the parents are not citizens of the United States and they are citizens of another country, then their loyalty is with that other country, and we should assume the same of their children. Okay, here's another interesting paragraph. In providing that the persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens, the 14th Amendment undoubtedly had particular reference to securing the citizenship to the members of the colored race whose servile status had been obliterated by the 13th Amendment and who had been born in the United States, but were not and never had been subject to any foreign power. They were not aliens, and even if they could be so regarded, this operated as a collective naturalization, and their political status could not be affected by any change of the laws for the naturalization of individuals. So again, this is kind of going to that other argument we talked about, the Trump admin potentially making that, hey, the original intent of this was for freed slaves and not for children of immigrants. Okay, so there you have it. I hope you learned something and can better expect what's coming down the pipeline from the Supreme Court, how the analysis and the oral arguments might shape up, where the court might have its stronger or weaker arguments that it's sympathetic to or likely to disregard. And again, I hope you appreciate that this is really from a purely intellectual or academic perspective. I am a law student and I'm not seeking to throw my hat in the ring of politics. I'd be really curious to know what you think, if you've read this case, and if you have any thoughts on it, things I missed. Again, there is so much information here. I feel as though I could barely scratch the surface, but I want to be respectful of your time. So let me know what I missed in the comments, and have a great rest of your day.